Okay. Well, thank you for your arguments this morning. We're going to talk to everyone about the arguments and give you our thoughts and pointers and so on. But I think I speak on behalf of the group in saying that the caliber of arguments we had was just superb and really better than, frankly, probably 90% of what I see on a daily basis. I wish we had lawyers like this in front of us all the time. I take it in a heartbeat. The winners are the appellants. So just sort of get that out. It is a difficult decision, but that's what it is. Should we just talk? All right.
I agree with everything Judge Kepler said. I think you all were fantastic, both groups. I just really encourage you to continue to practice like this. I think 90% is an accurate number, that you're better than 90% of the people out there, and really did a fantastic job. We'll talk both about the briefs and the arguments, but I thought the briefs were well done. As Judge Kepler, I think, will point out as well, I would watch out for typographical errors, font changes. I know when two of you are doing it together, sometimes things like that happen, and I'd be very, very careful. I think, in the real world, to me, and I think we talked about this a little, it goes to credibility. And so I'd just be careful with things like that. With regards, but I thought overall they were very well done, very helpful. I appreciated the briefs. The other thing I would say is that you all did a really good job with eye contact, with not mumbling. I would never read from anything. I think I noticed that more than maybe other people do. And so I wouldn't read. I'd be careful. I had some, I used to argue, I know how hard it is. I had some bad situations that I needed to work on. Once you put your hands in your pockets, you may not even notice that. I'd be very careful about how you go about that. Just a couple things, Dan. I thought you were really good, poised, good acknowledgement of certain issues and then answering questions. I thought you held the right lines on most occasions and really drilled down to what we were asking. Chris, I thought your eye contact as well was fantastic. I thought you did a nice job with the Williams case. I have here, I can't remember what it was, but that you had a good point about cross-examination. I think it was the historical nature. You talked about that. I really thought that was good. You both exhibited a clear knowledge of the materials and the case law. The only kind of constructive thing I would give you is the prayer for relief you kind of stumbled over after you asked to do it. And, I would say, I know that's kind of form, and maybe Judge Kaplan or one of the other judges would have insight into this, but I would say that we know what you're asking for. And so every lawyer does it, but I'm like, you know what, I'd rather hear the argument and the reasons. But maybe you have to do it for some reason that I'm not aware of. Let's see who's. No, I can't even read my own handwriting. Do you want to? One of you want to do the other side, and then I'll add in.
Let me begin with the briefs. When I received the briefs, I was very impressed by what I read and what I saw. And sort of the way I gauge legal writing is, particularly from law students, is would I hire one of these to be my law clerk? Are they of that caliber? And all four of you satisfied that criterion, I will say. So the briefs are impressive. They're very well presented. I think, and I had mentioned this to Ben, I was very active in moot court in law school. I was on the moot court board. And as try as one does in setting these arguments up, the issues up for moot court, there's always the more persuasive side, the more appealing and more compelling side. And to the extent you're not handed that side, as an advocate, you have a tougher time putting your arguments together and being as persuasive as you want to be. In terms of the oral arguments presented here today, you've all got the essentials down. You know that you stop talking when one of us interrupts you, and we interrupted a lot.
Particularly Judge DePar.
And it's not what you want. It's really not what you want, because you've prepared your oral arguments, you've got things you want to say and you want to get through, and you probably didn't even get to touch on maybe even 10% of what you had in your own minds. The flip side of that is you never want to be there at the podium at an oral argument and have a silent bench without a question, because then you're hearing your own voice and you're wondering, am I getting across to them or not? So there's sort of a balance. You all had the right eye contact, the right demeanor, the right level of respect, and when you struggled to answer questions, you were earnest in your efforts to get us the answer to some very hard questions from the bench this morning. All I can say is you're all on the right path. You did an excellent job, and I congratulate all four of you.
I would certainly echo those thoughts, and doing this argument reminds me of my experience in doing some cases where you hate to make one side not win. I mean, sometimes the lawyering on both sides is so good that you really, on a personal level, you feel sincere regret that you can't just have everybody win. And that's how I felt today. But to talk about the arguments, I would agree about the no reading point. It's good that nobody did. That is a pitfall, I think, that a lot of people have. The prayer for relief, it's funny. I think it is actually important to do that.
I would take his word.
It's because it can be complicated. You know, I mean, you really have to think about exactly, in a court of appeals, exactly what you're asking for. Yeah, and I remember an argument in the 11th Circuit where there had been a trial, a jury verdict in favor of a plaintiff. I was representing a defendant on appeal, and we had an argument that, number one, they hadn't had enough proof to survive a directed verdict motion, and number two, that there was some evidence that came in that shouldn't have come in. And it was probably the best. It was the best panel I ever argued in front of as a lawyer. And Stanley Birch on that court said the argument went well. And at the end, he just sort of threw up his hands and says, "All right, what do you want us to do?" And you know, you better, when you get a question like that, which is a great question, you better have an exact answer. So the answer wasn't just, I want you to reverse, because, well, reverse what exactly? What does that mean? We have another trial? You know, I said reverse and render judgment for Daimler Chrysler Corporation. So you have to know exactly what you want. If it's a summary judgment case where you're trying to reverse a summary judgment, are you trying to get an order that says the plaintiff can never, or the defendant can never get summary judgment here? Or are you just saying maybe the district court used the wrong standard and so vacate it, but that's still alive? You need to understand those technicalities before you put your prayer in the